Welcome everybody to the panel on health, big data, and privacy. My name is Ed Felten. I'm the Kahn Professor of Computer Science and Public Affairs here at Princeton, the Director of the Center for Information Technology Policy. Let me very quickly introduce the panelists. Their longer and very impressive biographies are in your packets. On my left is Julie Brill, who is a commissioner at the Federal Trade Commission and a Princeton alum. In a minute, I'll ask her to speak first. John Jacobi is the Dix Professor of Health Law and Policy at Seton Hall University. And on my far left, Joel Reidenberg is the Microsoft Visiting Professor of Information Technology Policy here at Princeton, and more permanently, the Waxman Professor of Law at Fordham University. So as far as the structure goes, I'll ask each panelist to speak for roughly 5 minutes with some introductory remarks. We'll have some conversation among the panelists up here, and then we'll open it up to Q&A. So let me ask Commissioner Brill to speak first.
Sure. Thanks, Ed, and thanks to Princeton and the Woodrow Wilson School for inviting me to speak here today. It's a really interesting question that our keynote speaker asked, which was, are we done with privacy? And I kind of think he was asking it slightly facetiously because I think he realizes that privacy is an incredibly important issue and one that we need to address if we're going to realize the benefits of big data, particularly in the health field. McKinsey, who's well known to many of you, an important analyst both in healthcare and elsewhere, has described privacy as the third rail in the public discussion about big data. I am a firm believer that big data has a lot of potential benefits. Health is a great area of where many of those potential benefits may arise, and we've heard a lot about that through the day today. But I think in order for that to happen, we're going to need to create a trusted environment in which the big data projects and big data efforts can flow. One of the things that I focus on as a commissioner at the Federal Trade Commission, we don't really regulate doctors. We don't regulate hospitals in any sense in the way that either CMS does or even FDA might. We focus on the commercial sphere. And of course, hospitals and doctors all fall within the commercial sphere. And what we look at are things, everything from ad substantiation to data security and privacy to mergers and acquisitions and anti-competitive practices. So we have a very, very broad mandate. But with respect to this issue, we have spent quite a bit of time looking at privacy and at data security. When you step back and look at the laws that we have in the United States dealing with privacy, they were created mostly in the 1990s, and what they've done is they've selected, the Congress and frankly the states as well, have selected certain areas that have been deemed to be sensitive, certain types of information that's sensitive. Health is clearly one. That's the HIPAA law that many of you are familiar with. Congress has also said that financial information is sensitive. Information about kids is sensitive. Information that's used for credit, employment, housing, or insurance under the Fair Credit Reporting Act, that's sensitive. And frankly, information or other activities that can be used for discriminatory purposes is also going to be looked at with a red flag, a heightened scrutiny and could raise some red flags. These laws, created in the 1990s, did a pretty good job at selecting the areas that we should care about. But what they did not really do very well is envision the way data would flow in the 2010s and how we're currently dealing with data. So the laws created silos. They said, okay, we'll look at doctors, insurance companies, hospitals, their business associates. Those folks we're going to regulate. We're going to say they all fall under HIPAA. But health information now certainly flows through those entities, but it's flowing in many, many other places. And so you've got laws that respect silos, but data that don't respect silos. And I view that as one of the fundamental problems with respect to privacy and why we need to be looking at the way data is flowing in the way health information is flowing in a more holistic way. So some of the things that you all have, I haven't heard about it yet today, but I'm sure many of you know. There's a bunch of examples out there in the commercial realm of how health information is being used in ways that are bothersome, if not deeply troubling to many people. There's the example of Target before it became unfortunate victim of a big data breach. It was involved in its own interesting data experiment where it looked at purchases of its customers and was able to develop a pregnancy predictor score. And it did this through pretty innocuous information, so it appears. And the score was able to predict not just which of its female consumers were pregnant, but when their due date was. And they developed this and used it to provide coupons to their consumers. But it obviously was dealing with health information and led to some pretty troublesome results in that, in one case in particular that was discussed in a New York Times Magazine article over a year ago now, a young woman was sent coupons that included these coupons developed through the pregnancy predictor score. Dad got very upset, called Target, said, "What are you doing? There's nobody pregnant here." Fast forward 2 or 3 days later, he called back and apologized and said, "Well, I guess there were things going on that I didn't know." So that's what Target did, developing, and a big part of the big data project is not just analyzing information, it is creating information. So again, from innocuous retail purchases, health information is created. And you can imagine not just health information being created about pregnancy, but also, does this person likely have diabetes? Does this person likely have cancer or other condition, or some mental illness, depression or whatever? There are firms that are looking at social networks, looking at other publicly available information, and developing lists about people that are based on their health conditions or likely health conditions. There have been reports about medical trial search firms that try to determine, based on posts, based on the kind of cars that people own, based on how many people are in their homes, whether or not they are obese or potentially diabetics, and then they call them and say, "Would you like to participate in a medical trial?" Now, some of you out there may say, "Gee, that's great. They're offering something to a consumer that the consumer might not otherwise have known about." But I think many people consider this to be deeply troubling, especially those who receive these calls and wonder, how did this person know that I was obese? Or why does this person think I'm diabetic? Again, there's no doctor-patient relationship here. There's no HIPAA protection whatsoever. Let me fast forward to the Internet of Things. I mean, we have, I think, largely so far today, not entirely, but largely been talking about information that is available in medical records, information that's going to be available online to consumers through apps. But we are really rapidly moving into the world of connected devices. Fitbits, other kinds of devices that consumers are going to use. Their refrigerators, which will be able to detect how much they're eating, how often they're going to the refrigerator, and what they're eating. All sorts of other devices are going to be able to either provide direct health information or will be used to infer some pretty important health information. Again, depending upon where this information flows, to the extent that it's a medical device, I went to the Consumer Electronics Show in Las Vegas, and one company has developed something they call a MIMO. It's a onesie for a baby, and it goes on a little tiny baby and can detect everything from heart rate and respiration and all sorts of things. My guess is that that device will be likely used in some kind of a HIPAA context, at least I certainly hope so, where the information will be flowing to the doctors. But to the extent that it's not, to the extent that it's just flowing directly to the consumer, to the parent, again, it's not going to be something that is regulated. And some of my concerns around the devices are consumers might not even realize that they're dealing with a connected device. There's no consumer interface. Where do they give notice and choice? Where do they give any form of consent if there's no direct consumer interface? So really quickly, I know we've only got 5 minutes, really quickly, why do I care about whether information is flowing outside of those silos that I described? I care because we did a pretty good job in the 90s of instilling consumer protections within those silos. So, for instance, under the Fair Credit Reporting Act, consumers have the right to receive a notice if information is used for an adverse decision. If they're given a loan at a higher rate, if they're denied insurance or the insurance costs more, whether it's based on health information or whether it's based on other kinds of information, if consumers receive or are adversely affected, they get notice about that. They also get to look at the information and correct it if it's wrong. Those access and correction rights, I think, are incredibly important and would not exist outside of those laws. And finally, with respect to marketing, marketing of products and services that might be based on health information or based on other kinds of information that's created through the data broker ecosystem, and maybe we'll talk about that a little bit in the Q&A. Most data brokers provide suppression rights. That is, you can say, okay, I don't want to be marketed based on all of that information. But consumers have no idea who these data brokers are. So one of the things that we need to be talking about is how to build much more transparency into this system. So to the extent that we want to rely on consumers to manage their own privacy, and I've got some questions about how effectively consumers can actually do that, and I hope we get into the discussion about that. But to the extent that we do want to have a privacy self-management regime, or at least partially that, I think we need to have a lot more transparency about how data is flowing. So thanks.
Thanks. Professor Jacobi.
Okay, thank you. This is a really terrific program, and I want to thank the Nicholson Foundation for putting it together. One of the things that I really like about this program is that there's a real mix of people who are health people and people who are non-health tech people, and then there are some people who are tech health people. But I think that there are two important arcs that are at work in society when it comes to data issues these days. One is the arc of sort of healthcare delivery, clinical data analysis, and we heard a lot about that this morning. The other is the big data sort of meme, I guess I should say, if I'm talking about big data, that involves the aggregation of disparate databases and the application of sophisticated new algorithms and analytic tools to attempt to discern correlations. And this is always true when I come to a conference like this with big data in the title. I sit in my seat and think, when are we going to talk about big data? And that we got a little bit of that at the lunchtime speaker. But you know what? All of the pieces here are incredibly important. But if I can just spend a second and describe what I think is a taxonomy of the different ways that we use the term big data. Just three categories. Not everything fits into it. I can't figure out how all payer claims databases fit into it. But the reason I'm raising it is because it highlights what I think is the important privacy issue. And I've learned, I have to say, I've learned two things already in this conference. I've learned lots of things, but the two that I'd like to share is, one, I'm going to pay a lot of attention to what the FTC says, because in preparation for this conference, looking at the way the FTC thinks about non-health databases and non-health data collection is so smart and so interesting in dealing with thinking about structural protections within firms and transparency. Very different than HIPAA and the common rule, which end up being quite clumsy when it comes to protecting people in healthcare delivery. So I learned that to pay attention to the FTC. And I'm sorry, I should have been paying attention to the FTC all along. I'm sorry about that.
So I forgive you.
Thank you. But the second thing is that privacy matters. Now, a lot of people, I've heard a lot of people today, and a lot of people otherwise say, some of them whose names start with Z, say that nobody cares about privacy anymore. Get over it. Privacy's over. And I've heard a lot of people say, younger people don't care about privacy the way we do. Well, I have a 21-year-old child, And she doesn't care about a lot of things the way that I do, and I hope that she grows out of that. I'm not willing to go all the way on her say-so on whether privacy is important or not, particularly because I spent years representing HIV-positive people who were denied access to health care and employment and housing and all sorts of things because of a little piece of health data that became known. So I understand that health privacy is changing. Our understanding of it is changing, how we use it is changing, and so on, but it matters. So let me just spend a second on my taxonomy, and I hope it's useful. I mean, the first category is clinical data, and we've heard a lot about that, and there's a ton of promise there. If Geisinger can move from Shangri-La, whatever that is in Pennsylvania, to bring those tools to New Jersey, and there are some very forward-looking people in New Jersey. Don't get me wrong, but it is not a state that is breaking new ground in integrated delivery. It is catching up quickly and doing a lot of good work, but the kind of forward-thinking integrated delivery health information systems that Geisinger and Cleveland Clinic and Kaiser are using is really terrific. It really helps patients. There's no question about it. That's really great stuff. And that's easy from a privacy perspective, right? It's one firm. You get consent, or as become a verb, you consent someone, and then you can gather the information. It's all within the same firm. You're using it for healthcare treatment purposes. Easy. The second category is the category of health analysis that is sort of public health. So you gather together large quantities of data in order to determine whether there's an outbreak of anthrax or whatever, or to determine the COPD rates in different parts of a state and so on. And a lot of that data is relatively easy from the health privacy perspective, because most of it's de-identified. And unless you're a public health agency, most of it's going to be de-identified. So that's easy. The third category is big data, right? It is the agglomeration, the accumulation, or the aggregation of disparate sets of sometimes data that gets thrown into a bucket, and interesting operations are performed on it. Sometimes you find out that someone's pregnant because they changed from a scented to an unscented hand lotion. Sometimes you find all sorts of interesting things out. Very interesting data, but it's not PHI. It's not personalized health information. It's commercial information that either properly or improperly is being gathered, and if it's improper, then Julie will find out and woe betide you. But even if it's properly being gathered, it's not personal health information. It's being gathered from commercial sector and banking sector and so on. So legally, what is done about that, and I think that the FTC is doing an interesting job trying to corral the use of that information. Now, what I want to talk about is one aspect of big data, and then I want to give you an example of why the example that what this category is, new category is interesting, and then I'll be finished. But so what I want to talk about is what you do when you want to combine the first category, that is health information, with the third category, big data. So say that you want to, and here's my example. So say you know, which we do, that people with persistent and serious mental illness live 25 fewer years than people who don't. Everybody knows that. It's a terrible thing. It's one of the big public health problems that we have in this country. We think we know part of it. Now, part of it is that we just give them crappy health care, and too often. But part of it is unknown. We have theories. We have theories about co-location of physical and mental health and so on. I'm sure that a lot of it has to do with social determinants, but we don't really know. So suppose that we would really like to put enough information together to be able to draw some conclusions about that population. Well, what do? Well, we might want to combine the first category. There's lots of encounter and payment data, and then lay on top of that a lot of demographic data. You could think about geography, you could think about transportation, you could think about employment, you could think about contact with the criminal justice system, you could think about all sorts of things, and try to mush those things together. I agree with a hypothesis, if possible, but even without, to start looking for correlations. That might be a really useful thing to do, and something that it's worth our time to sort out how the legal privacy protections would work through that system. But let me tell you what the barrier is to making that as useful as it might be. And I have a friend who actually does some of works for a data broker. Don't tell anybody, but he works for a data broker. And I was describing to him what I was going to talk about here, and I said, "Does the word longitudinality mean anything to you?" And he said, "No, but I like it." And he has appropriated it, so I won't be in the Oxford English Dictionary. Actually, it's used in other contexts. But here's the problem with longitudinality. So you've got this database. It combines clinical data of people who have severe and persistent mental illness, and it lays on top of it a lot of this big data stuff. And you're looking at correlations. Well, suppose that we want to know 5 years from now what the advent of the ACA has done. Lots more people eligible for Medicaid. There's been some clinical trials of some sort on co-locations that are sort of the best we can do if we're not going to use data analytics. So maybe we'd like to go back and look at those people 5 years from now. You can't. That data set is static, right? It's because you've de-identified the data in order to create that bigger set. So if you've de-identified the data in order to create the bigger set, when you come back in 2 years, you can redo it, or 5 years, you can redo it. You can get new clinical data, overlay new big data, but it's different data. You can't go back and see. You can't go back, sort of notionally, you can't go back and see whether the person who now has heart disease took Vioxx, or whether the person, in my example, who's doing well, notwithstanding a 15-year diagnosis of paranoid schizophrenia, is doing better than he was before he acquired Medicaid because of the ACA. You would have to this is where longitudinality comes in. So, and I'm sorry if it's a clumsy word, but so you've got the data, and then it's de-identified. But if you want to follow that cohort or the whole huge cohort longitudinally, you would have to, in some sense, re-identify and then de-identify the information to figure out what happened. Now, that's not always a problem with use of big data, but it is in that example, and I think it will be often. I think that thinking through how we're going to use for public health purposes the big data in combination with what is increasingly going to be very good clinical data will require crosswalking a bit of what I do as a health lawyer and what Julie does at the FTC, and think through how we can refashion the way this information comes together. And just finally, the idea that they're entirely different, that it's appropriate to use different privacy notions with big data than with clinical data is just wrong. My friend, the data broker, when I said to him, okay, if you've got access to all the Facebook data of people, can you, and other social data, can you, to a 95% confidence level, tell me who has chronic illness, an STI, HIV? And he said, oh yeah, absolutely. Okay, so it's not PHI. I mean, he's getting the information from Target, from Facebook, and from all sorts of places, but he knows very personal information about someone I dare say, as high a degree of confidence as most physicians do. And that makes it something that is akin to PHI, personal health information, and therefore we shouldn't be thinking HIPAA over here and FTC over there. We should be thinking about doing things the way the FTC talks about doing it, thinking about structures in firms to give us assurance that information is well managed, and thinking about what we mean when we talk about patient choice and translating into something useful, so that we both get what people have talked about here, that is empowering consumers in a way that's useful, but also making sure that we push into the proprietors of health information, whether they're clinical or non-clinical, some responsibility for having having information compliance officers, for having a compliance plan, for knowing what they're doing with the information, and for being responsible, and for being audited by the FTC or somebody else on how well they're doing those things.
Thanks. Professor Reidenberg.
Thank you. It's a real honor to be able to join this panel, though I do feel a bit like I will be the thunderstorm at the parade. And I'm going to talk about privacy in really four points I want to make. The first one is probably the biggest takeaway, which is privacy will crash big data if we don't get it right. We've seen this quite recently in a very prominent big data push in the education sector. Those of you who have been watching what's been happening with InBloom, it's a $100 million project, big data project to be able to make better decisions for educational policy. It's on hold right now. The 9 pilot states have all pulled out because of privacy concerns. It wasn't handled well from the start. At the moment, the project is on the rocks. We'll see where it goes in the future. The second point, and this is picking up on Commissioner Brill's comment about siloed laws. Privacy law is simply not ready today to deal with many of the issues that we've been hearing about all morning and afternoon. And I think the comments that John just made about the different categories, our privacy law just doesn't handle it well. Many of you are familiar with HIPAA. Well, HIPAA is very limited in this context. It's only addressing certain types of entities, but the Big Data Project has multiple types of participants. Here's an interesting one. Raise your hand if you think Dunkin' Donuts is covered by HIPAA. Not a hand in the room. But what about that example where Dunkin' Donuts information was going to be sent to your physician to determine whether or not you're following your regimen for diabetes? Well, HIPAA is probably not going to cover that. I can't imagine how you could claim Dunkin' Donuts in that instance it's not a health plan, it's not a medical care provider. But nevertheless, that data is being used for diagnostic purposes, being transferred by Dunkin' Donuts. If we look at what Commissioner Brill had mentioned, sensitive data, right? Innocuous data today is sensitive health information. And I'll come back to the Dunkin' Donuts example. The purchase of a Dunkin' Donut, right? You don't think of that as being health information, but transferred to your doctor to determine how you're doing on your diabetes program, all of a sudden it becomes very sensitive health information. We have so many different kinds of participants and types of behavior, types of actors behaving in different ways as part of big data projects. So the one I think we need to worry significantly about, we haven't spoken much about, are those that are consumer-facing organizations collecting data, seeking to engage consumers in behavior-altering activities. So things like the Fitbit. Right? The Fitbit's collecting a lot of information, health information. How's it going to be used? It's currently unregulated effectively. Third point, big data practices will outrage the public in the health area. So I heard this morning, no particular offense intended, our very first keynote this morning talked about using a credit score as a factor in making a determination of discharge from a hospital. I think most Americans would find that an offensive practice, that their financial that something about their financial credibility determines whether or not they can get out of a hospital. we learn a lot about price optimization for things like healthcare products and services. This is one of the promises and hopes of the Big Data Project. Well, you can talk about that as pricing by stereotype. Right? What are you doing? You're profiling individuals, you're bucketing them for a higher or lower price based on a stereotype. We will find discriminatory impact from those kinds of practices. And how are we going to deal with that? And the fourth, and I promised I'd make it very short, the fourth and last point is I think privacy needs to be institutionalized for big data programs in the health sector to be successful. And what do we mean by that? We mean we need to figure out ways of baking accountability and baking fair information practices into big data systems. And these are ecosystems that are very complex with very opaque actors to all of the parties involved, not just the patients, not just consumers. I was having an interesting conversation at lunch today with someone who has a project going, and unbeknownst to that individual, her company was using a cloud service provider, a third-party service provider, to actually store the data. So it's just a great example. Right? Here's someone who's in the business, working on a project, and thought only her company held the data, which in fact wasn't the case. So what happens in privacy in that system? Depends on what the contract says between the company and the cloud service provider. Can the cloud service provider keep that data after the company's contract ceases? Right? This is sensitive health information that's being collected there. So the systems are very opaque. We have to figure out ways of baking in accountability to each of the actors, accountability to data subjects, to patients. How are we going to deal with data breach? It will happen. It's inevitable. How are we going to deal with open data? We heard the conversations this morning. Anisha's keynote was very upbeat on open data. I look at it from a privacy point of view and find it terrifying. Why? Because it's very easy to de-identify, to de-anonymize personal information. And there are lots of risks that that imposes for individuals, from physical safety risks to all sorts of other types of risks. The accuracy of the information. You're making decisions on data that becomes polluted and inaccurate. If it concerns their health, as we heard from one of the physicians, patients will die. This is part of what fair information practices tries to address, the integrity and quality of the data. So I'll conclude with this. I think we need to bake this in. I'm very optimistic because it means that my students will have jobs for a very long period of time.
Thank you all. We have a lot to think about. I'd like to ask the panelists one question myself, and then we'll open it up to questions from the floor. I think all of you talked in one way or another about the difficulty of drawing a line between health and non-health, both from the standpoint of institutions and providers, also in terms of types of data, and in fact, simply the problem that even data that is clearly non-health data can be used to infer a status that clearly relates to health, such as using the purchases of hand lotion to make an inference about pregnancy. So given the difficulties of drawing those lines, and given that currently we have very separate regimes for dealing with privacy in these settings, is this a sustainable situation, or how can we bring these worlds together, or can we find a way to keep them separate and operate both of them in an effective way?
So I can jump in on that. I mean, I think, again, one message, if I have a message for most of you who are here today in the healthcare world, and if you're working in the healthcare world, again, HIPAA presents challenges to you in terms of compliance, and I'm well aware of that in terms of, for instance, how to deal with de-identified information and whatnot. What I'm trying to let you know is that there's all this commercial data floating around, and we do now think of them separately, but that is, the law treats them separately. I do not think of them separately anymore, and I don't think that you should think of them separately anymore. So to the extent that you're giving to your patients, some kind of a monitor that, they're supposed to go off and monitor their own health, their own attributes, what's happening with their weight, with what they're eating, whatever it is, and that's going to be health data. And you all can do a tremendous amount within your organizations to start to bring some of the concerns that are reflected in HIPAA to this commercial sector to the extent that you're interfacing with it. So John was mentioning, you know, we have a lot of recommendations about how commercial information should be collected, stored, and used, and then reused when it's in a sensitive context, which is what we're talking about here. Chief privacy officers, incredibly important. Having some sort of ethical review within your institution. You know, someone came out with a proposal to mimic the institutional review boards, and I know that that's kind of a dirty word for some folks, especially researchers, but to take some of the construct of an institutional review board and put that in place for consumer data. So you have some review going on that's independent of the researchers and actually independent of the institution that's looking at the big data research projects, looking at what's happening with data flows, and determining whether or not it's appropriately privacy protective. There's a lot of talk now about risk-based frameworks for looking at privacy. Now, I don't think that we should change our fair information privacy practices, which are known as FIPS or anything like that, to substitute for a risk-based framework. But I do think what a risk-based framework would do is if you all start thinking about the data flows as risk, that both from a data breach perspective as well as a privacy perspective, what you're handling is very sensitive information that creates risk for your institutions. I think what that will do is heighten the issue, will raise it up to the C-suite level, and that's where this issue, in my view, belongs. John mentioned we audit a lot of folks. We don't actually audit everybody. We audit the folks that we put under 20-year orders. And actually, they have to audit themselves and then provide us with the audits. So Facebook, Google, MySpace, and many, many other companies that are not household names are all subject to orders right now with the FTC that puts them in, that places a requirement on them to do self-audits and then provide to us those results. You don't want to be in that situation. You don't want to come under order with us, and that's why we try. Believe me, I mean, we're nice people, but it's just not worth it. So what you want to do, I think, is follow some of the recommendations that we make that John, you know, going to our website and whatnot, some of the ones that I'm outlining, and we can talk about this some more later, but I think what you want to do is be proactive, think about privacy risks up front, build privacy protections into the products you're providing, and then also when you're interfacing with the commercial sphere, make sure they're doing the same thing. I think that that's probably the best way. I mean, we'll never fully bridge the gap, right? I mean, until we have baseline privacy legislation in this country, and while I'm a big supporter of that, I'm just not holding my breath right now. So I don't know that we'll ever fully bridge that gap.
Well, let me just say one real quick thing. I agree with what I take as Joel's point, that the siloing of the laws is a very ineffective way for us to try to deal with this issue. But I just want to say that from a law reform perspective, whenever I have been involved in law reform efforts, I'm always conscious of not wanting to give up the protection that I have until something else is in place. And I think that means that even if there were any chance that major privacy legislation would work its way through Congress any time in our lifetimes, it would. I would say that one of the things we have to be aware of is that the protections of HIPAA and other privacy legislation is going to be there because that is, clumsy as it is, protection of very sensitive privacy norms. Could it be done better? Absolutely. Should it be done better? Yes. But in the meantime, I think that we will continue to have these silos, and we're going to have to deal with them, but try to work creatively, but certainly within the law, to harmonize the systems that exist out there.
Yeah, I was just going to say, I think, Ed, your question is very well on point. I think it is an unsustainable system legal system that we have right now, where we make a distinction between health versus non-health information, because it's really about the uses and how the data is used, why it may have been picked up in the first place. I share the view that it's not likely Congress is going to step into the act anytime soon, and I think one of the things that means is that in the next couple of years, we're going to have a very uncertain and consequently both unstable and expensive system for those who are developing big data applications, because it's a moving target. The privacy expectations of the public keep getting ratcheted up, and there aren't any clear guidelines here. So I think it will make for a very unstable and costly, in a way, system.
Thanks. Do we have any questions from the floor? Yes.
I think this panel is taking a very legal perspective, and as Julie said, it's all about risk, right? The risk that privacy will be violated, the risk that data will be lost or somebody will be compromised. But I think it would be nice to have some sense of the balance between risk and opportunity, right? Because if no one has access to these data, then more people will die because breakthroughs won't happen that would have happened otherwise, right? So there's costs and benefits of big data and big data applications, and so far the panel's really only talked about the risks, the costs. So I guess I'd like to hear some sense of how you make those balances.
So I think I started out by saying I'm actually a big data optimist. I want big data to flourish, and that's why I think this issue needs to be resolved. I do think that there's great potential for big data projects and analytics to be incredibly helpful going forward. It's interesting. Our jurisdiction, I can't help it but to be legal, because frankly the privacy discussion it's a norms discussion, it's an ethical discussion, it's a structural discussion, but it is also a legal discussion. And when we look at cases from the Federal Trade Commission perspective, we have basically two areas where we can focus on big data. We have our Children's Online Privacy Protection Act, we have the Fair Credit Reporting Act. Those, in theory, could touch on big data, but outside of those areas, we have our deception jurisdiction and our unfairness jurisdiction. Just looking at unfairness, that has built into it a balancing test. We can't bring a case against a company if the company is able to show that the benefits to consumers or to competition outweigh the harm that we're concerned about. What I am worried about going forward, I actually think that we'll end up using our unfairness jurisdiction more and more with respect to big data. But what I think is very important is, rather than simply saying big data is going to save lives, therefore you get out of this space, FTC, or get out of this space, state AGs, is I think we need to have the same evidentiary demands on the benefits of any big data project as we have placed on ourselves to demonstrate harm in a privacy context. So I think it's really important, and just to spell out for a minute what I mean, is rather than simply having a vague notion that, oh, this is going to benefit mankind and we'll all save money and we'll all live to be 150 years old if this project is not impeded. Again, I just think that we need to be specific about what those benefits really are with respect to any particular project or firm and what a firm is doing, and then balance that with the harms. And that's built into what we do. So that's the way I look at it, and I think that may become a very important issue going forward.
Yeah, I was just going to add, I think it's a great question. I think one of the difficulties in this area is the benefits are speculative in many ways right now. It's a hope. The privacy harms are inchoate. We can make lots of philosophical arguments about what the harms are to one's autonomy, integrity as an individual. We can look at the privacy harms that are inferred for our democracy's functioning if individuals don't have a sense of seclusion and a control over their information. We can look at privacy in terms of power relationships between individuals and organizations and society and the government. So there are lots of different ways we can look at it. But at the same time, when you look at the benefits, we're hopeful as opposed to provable right now. And I think that we need to take that also with a healthy skepticism. We've seen and have many examples, and we have legislation because of very clear privacy harms that have taken place over the years. And I think one of the best analogies in this environment is the Fair Credit Reporting Act from 1970. If you look at what happened in the 60s that led up to the 1970 Fair Credit Reporting Act, which is our first privacy statute in the United States, the credit reporting industry was looking at computerizing and trying to analyze on a mass scale consumer reports. It was a very opaque industry. Lots of adverse consequences were happening to real people. And there was a parade of horribles brought before Congress. Industry kicked and screamed that this was going to destroy consumer credit in the United States if we had a statute. Congress passes the statute. Fast forward 26 years, 1996 amendments. The same lobby groups that were arguing it would destroy the statute creating a privacy regime would destroy all of the opportunities of credit, were arguing to Congress because of the Fair Credit Reporting Act, the U.S. had the most robust credit market in the world. So it's, it's a hard one, but it's a great question.
Just real briefly, I'm a lawyer. I worry about people being taken out of a room with a raincoat over their heads and shackles. So I care about whether they're breaking the law or not. I've also worked in, and I'm looking around the room, there are a lot of people here who have worked in government, and everybody knows that the law lags society in many respects. So I think that there are a lot of ways forward. In New Jersey, there are a lot of things that we can do cooperatively with data that is clearly on the right side of the law that we're not doing, that we should do. We should help to develop with our eyes on protecting consumers at the same time, developing data to save lives, to help people to the extent that we can prove that it does, in part to build a record that such efforts actually are useful and non-speculative, so that as pressure builds to reform the law, there's a record to support the assertion that we ought to.
I'd like to make a brief pitch here as well for the opportunities to use new technology to make these trade-offs between privacy and utility of data less harsh. There's a tendency to think of it as a zero-sum trade-off. We can have this or we can have that. But I think if we think creatively about how to use new technologies, there are actually opportunities where we can soften that trade-off. We can't eliminate the tension between utility and privacy, but we can do better. And one of the ways to do that is to think beyond the sort of limited paradigm that seems to be built into HIPAA that says we're going to scrub data and then give it to you, right? If we move beyond a model of scrub and transfer and allow other kinds of models, like allowing you to send statistical queries into the data while not holding the data yourself and other kinds of advanced methods, we can often do better in protecting privacy and having utility at the same time. So I'm actually less of a pessimist about this trade-off than I think that some other folks are.
Thanks very much. I think this contrast between what's going on in the rest of the world and what's going on in medicine is very useful, and it's interesting to me that a health insurance company, for example, that you enroll with can then go out and get 2,000 variables about you, understand everything about you very deeply, and you've never given permission, or if you've given permission, it's deeply within some agreement that you've signed to be part of their plan. The hospitals, I understand many hospitals, once you get admitted, will then contract with a firm to find out what your net worth is, to see whether or not you're a kind of person who they should give to the development office. So they should decide whether or not they can ask you for donations without ever having asked you any permission. So I'm seeing like these two parallel worlds going on, and I'm personally struggling with this idea about how to bridge this, because I'm trying to listen very intently to you guys, and it's hard for me to listen so closely to lawyers and try to really think about how it translates for me. I say that with deep respect. Because, you know, we're now in an era where there's no such thing as de-identification. We are so good that it doesn't matter. And the best example to me of that is the Netflix example. So, you know, Netflix ran the competition with their big data for the first one, and there's a whole story about that, and they didn't come up with a singular algorithm, but they came up with a hybrid algorithm that improved their prediction by about 10%, which they integrated and was a great success. So they said, well, we're going to do this again. You know, it's kind of an X Prize kind of deal. And you know that they canceled the second competition. Do you all know that? Do you know why they canceled the second competition? So you know what they're doing? They're giving people a bunch of movies from a bunch of anonymous people and saying, here's the history of which movies they watch, and you want to predict which movie they want to see next, or what kind of movies they might want to choose next. All they're doing, this is the slightest of databases. I mean, it's just, I've got, you know, hundreds of thousands of people, and here's movie history. And then pick what they wanted, because they said you could identify who the people were. So I don't even know how. But they actually canceled the whole competition because they said you could do that. Now imagine I've got deep medical data. We're at a point now where I can tell you de-identification is a fantasy. It is a fantasy. So where does that leave us with the aspiration to say we want researchers, or we want, you know, we want to be able to bring together this data for all the promise of the future? But the truth is, it has to be in some sort of protected environment where you aren't saying this is so de-identified that no harm could ever accrue. I mean, with you know, their hands tied behind their back, most sophisticated people could sort of figure out among who the top, at least 3 possibilities are of the people. And what I'm looking for you guys, that long prelude was about, is to get, what do you think are the solutions to this? Because with the way that the law is currently configured, or with the constraints that are being put on the medical care system, which aren't actually anywhere else, but with us, and we've got that responsibility, how are we going to move forward to protect the interests of individuals, including us? We're those people. And at the same time be able to the balance part. I just find it, I'm worried when people really realize there's no such thing as de-identification. There's no HIPAA-compliant de-identification. People can crack it.
So I guess let me respond to this first as the technology person up here. I agree that de-identification, the notion of de-identification, is much more difficult than it used to be, and there are fundamental questions about the theoretical soundness of de-identification in the first place. And that's one of the reasons why I think it's especially important to think about other technological approaches. There is an emerging theory of how to provide limited access to data in ways that provably protects against re-identification type of problems. And it's not quite ready for prime time, but there is hope that there will be new methods. But they do go beyond this sort of scrub and transfer model of interaction with data. It's more a model of you send in a query and we'll give you back an answer. And if we do if we build the system in the correct way, we can guarantee that you're not going to be able to learn much about any individual. So there is some hope of...
But the tension between trying to get personalized medicine and try to really understand patient level or detailed information...
If you want to go to an individual, if you want to treat an individual patient, you have to know about that patient, absolutely. But that's a different, if you will, a different sort of interaction. Right. That's a first-party interaction where it's easier for the patient to understand who they're giving access to and so on, as opposed to a third-party kind of setting where data is going to some other person the patient has never heard of. And consent and so on and risk is much harder for the patient to manage in that third-party setting compared to the direct relationship with the caregiver.
Mm-hmm. I want to say two quick things that are maybe somewhat hopeful. One is that a lot of the things that you were talking about have to do with either first-party contacts or clinical data within an integrated delivery system. That's relatively easy from a privacy perspective. I think that a lot of the research that you were talking about was clinical research in a sophisticated university medical center or an integrated delivery system. That can continue to occur. Clinical research is entirely
but only
possible.
I mean, I think the best research now is going to go across centers with teams, and I think that's where it's not, people aren't going to be just looking in their hospital or health system anymore. And anyway, I'm just sorry, but I'm just saying, I think that's why I'm talking about
In
finishing.
the FTC, when we did a major rethink of privacy in our 2012 report, talked not only, we had a 3-part recommendation on de-identification. Now, this is not HIPAA, this is not what HIPAA calls for, but this goes to John's point that we're thinking kind of more broadly and holistically. And what we said was, any de-identification should be as robust as technologically feasible, which doesn't necessarily stop at the 18 fields or so that HIPAA calls for, right? It could be more. But then it has social, we recommend social requirements as well, so that if you pass that data along to anyone, first of all, you as an entity that is dealing with de-identified data, you need to commit that you will not re-identify that data, you yourself as an institution. And then if you pass that information on to anyone else, you need to get them to commit that they will not re-identify or further pass along the data. That kind of a social commitment or, a promise is something that I think is very important as part of this de-identification enterprise. That it's not just a technological answer, it's what are you going to do once you have so-called de-identified it. That's going to be key going forward, I think.
Yeah, I guess I would make 2 points. One is I think the solutions are going to come in part from what Ed described. In the privacy world, it's known as privacy by design. It's the technological infrastructure using computational techniques that can do it. And in the second part that I think will have to be combined with that are red lines, things that we say are just not going to be acceptable. We've done this in other areas. If you think about housing, credit, and insurance, in each of those areas, we have banned the use of certain data items in consideration. So you can't use race, you can't use, in credit, for example, marital status, insurance. We've said this information cannot be used for these purposes. And I think we're going to have to find that we need to find some of those red lines.
Thanks. I'm afraid we're out of time. Please join me in thanking the panelists.